Welcome to today's program titled The Future of Equal Pay, Compliance, Trends, and Global Perspectives. At this time, all participants are in a listen-only mode. For those of you who are logged in to the live web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, later in the presentation, we will read the CLE attendance verification code. Please write this code down, as it will not be reread, and it is required on the CLE credit request form. During the program, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees within a day or two following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Annette Timon. Annette, please go ahead.
Thank you so much, and welcome to everybody who is joining us today. For those of you who've been part of these webinars, we've been doing these for several years, right around this time. Historically, you may have seen information in the news about Equal Pay Day and what that means, and we always use that particular time of the year to anchor and help employers think about pay issues, thinking about litigation, pay transparency, and related issues. So that's what we're here to do today. And we've been holding these webinars for almost 10 years now during this time to really level set and help employers on these important issues. So today I am thrilled to be joined by Caitlin Lane, who is a partner in our New York office. She spends a lot of time working on global, international issues, and so she's going to bring some perspectives from outside of the U.S. On equal pay issues. Christy Iacopetta is a partner, a subject matter expert on issues related to equal pay issues as well. And so she's going to spend some time talking about some of the state issues. And then for those that don't know me, my name is Annette Timon. I am the chair of our People Analytics Practice Group and spend a lot of time helping our clients navigate equal pay issues. And I'm here in our Chicago office. So with that, we'll turn to the next slide, and we are thrilled that we are going to be sharing and updating we've got 4 resources for you that we're going to be sharing in conjunction with this webinar. And the first is our 50-state equal pay reference guide, and it outlines all of the state laws on equal pay issues, with an emphasis on those states that really have carved out sort of a similar law to the Equal Pay Act. We also have our pay transparency wage range disclosure, and it's a compendium to our 50-state reference guide. So there you will see all of the states that have pay transparency requirements, and Christy's going to spend some time talking about that. We also have our developments in equal pay litigation. So that information, we've updated that with all of the recent cases that have been decided in 2024, just to continue to make sure we're highlighting the key trends in perspective. And then finally, we have the very important global equal pay desktop reference guide, which is similar in some respects to what we do stateside here in the US, but Caitlin and a team have also worked on what's happening outside of the U.S. So these resources, I think, really showcase who we are as a group, right, and as a team that works very closely with clients on everything from the counseling side, when it comes to how do I post my jobs, what do I have to disclose, to various reporting laws that Christy will talk about. We also assist in helping when litigation arises as well. So we have a very wide spectrum of support and services that we offer to clients, and we use the counseling work and the expertise to help us when litigation arises. And hopefully that doesn't happen, but to the extent it does, we have a team that is prepared to help with those issues as well. So on the next slide, I'll just give you a really quick overview of where we're headed. So the roadmap for today, we're going to kick it off with Christy, who's going to talk about state pay transparency and pay reporting requirements. Caitlin's going to then pick up the global landscape outside of the U.S. I will come back and join you on mostly the executive orders, and as a result, some of the trends that we're seeing there, and then we'll cap it off with strategic considerations in light of everything that you've heard today. So with that, I'm going to go ahead and turn it over to Christy.
Thanks, Annette. We can go to the next slide, please. As Annette mentioned, I'm going to focus on state pay transparency and pay data reporting within the United States. Next slide, please. I think we all have seen that within the United States, there has been a greater push for pay transparency. And because there is no federal law, different states and local jurisdictions have come online and made their own laws, enacted their own laws to require employers to disclose salary range information, excuse me, to both applicants and employees in these jurisdictions. And so those different state and local laws fall into three main buckets or categories, as you can see here. The first is requiring disclosure on the job postings. This is clearly the most popular amongst the jurisdictions that have laws. There's 16 of them currently with laws in place requiring the disclosures on the job postings themselves. The second bucket is upon request. So Cincinnati and Toledo, Ohio, both require disclosure to applicants and employees upon request. And then the last bucket is the requirement to disclose at certain points in the hiring process, whether that's after an initial interview or before an offer of compensation. And Connecticut, Nevada, and Rhode Island fall into that bucket there. So as you can see, though, the vast majority of the jurisdictions that have these pay disclosure laws are really leaning towards requiring it on the job postings themselves, including the three newest jurisdictions to come online later this year: Massachusetts, New Jersey, and Vermont. So on the next slide, you can just see visually the jurisdictions that have these laws in place. So the dark purple ones here are the jurisdictions with laws on the books currently. And we'll discuss in a minute how each jurisdiction has slightly different requirements, and it makes it really difficult for employers to track these and comply with all of these different requirements. But it's likely going to get even harder, because if we go to the next slide, you can see that there are a number of jurisdictions with pending legislation as well. So here on this chart, the dark purple again are the states with current legislation, and then the lighter purple are those that have pending legislation that could potentially come on the books sometime soon. So there's about 15 or so jurisdictions with pending legislation, and most of those jurisdictions are going to be, if they go through, requiring the disclosures on the job postings themselves. So kind of continuing with that trend of disclosure on the job postings. We're even seeing states like Connecticut, who has current laws that require disclosure upon an applicant's request or prior to or at the time of an offer. They now have pending legislation that would require the posting on, the disclosures on the job posting. So again, just showing a somewhat of a clearer trend moving towards that form of disclosure. So you might be thinking, hey, great, there seems to be some sort of alignment where states are going to be requiring the disclosures on the job postings. But the problem is they all have slight differences. So even though they fall into that bucket of requiring disclosure on the job postings, they have differences in what needs to be disclosed and how it needs to be disclosed. So if we go to the next slide, I'll just go through some of the trends we're seeing and some of the areas where we're seeing differences. We don't have time here for me to go through every detail of every single state. I think you might be a little bored if we did that, but I'm just going to highlight a few examples as we go through of some of the differences and the trends to look out for. So the first is jurisdiction-specific ranges. So most of the laws say you have to provide the pay range for the position, but Colorado, Illinois, Maryland, and New York have gone further, and they specify that the posted ranges have to be specific to their jurisdiction. So in Colorado and Illinois, if the wage range would vary based on the location within Colorado or Illinois, you have to provide that specific range for that specific location that you're posting for. In New York and Maryland, they say that the range must be for a single position and a single location. So if you have a posting that covers multiple locations in the state or multiple opportunities at different levels, you have to include separate ranges for each location and each opportunity. Some jurisdictions have specified how the range should be set. Many just say the range should be from the lowest to the highest salary or wage that the employer in good faith believes it will pay for the position. But Connecticut, Illinois, Maryland, and Rhode Island have specifically said you should set the range by reference to either any applicable pay scale, previously determined ranges of the wages, actual range of wages for those who are in the equivalent or comparable positions currently, or your budget for your budgeted amount for the position. And we have seen Illinois question, and some other jurisdictions too, actually question the wage range. Is it too broad? Is it really the true range? And California does have pending legislation now too, that if it's passed, it would require that the pay scale is no more than 10% above or below the mean pay rate for the range. So jurisdictions are definitely focusing on how you're setting those ranges and making sure that they're appropriate and not overly broad. Another trend that we're seeing is whether to include the starting salary range or the full range for the position. So Minnesota specifically says to provide the starting range. And then in Washington, they say you can provide the starting range. And if you provide the starting range, you must also provide the full range for the position there. We're also seeing some jurisdictions have specific requirements for positions that are based on commission, paid based on commission. So in New York, if they're paid, the position is paid solely on a commission basis, you have to disclose that in the posting. And then in Vermont, even if the position is paid only in part based on commission, you have to disclose that as well. And then in Vermont, you also have to disclose for tipped positions, you have to disclose the base range that goes along with those potential tips as well. I'd say kind of the biggest trend really is the additional requirement to disclose a general description of benefits and other compensation. There are about 7 jurisdictions that require that in addition to the salary range. There are not specific requirements to give the numbers or the amounts of those additional forms of compensation or benefits, just a general description of them. Also, for remote positions, many of the jurisdictions are cover any employees who could work in that jurisdiction, so they have a wide reach. We are, though, seeing in New York and Illinois, they're specifically limiting their reach to applicants who would report to a supervisor, an office, or another work site within the state. So they've limited that reach a little bit there. We also are seeing some jurisdictions require, in addition to the postings and the salary range disclosures, there are promotional opportunity notice requirements in Colorado, Illinois, and New Jersey. So in those areas, the employers have to announce, post, or otherwise make known any promotional opportunities. And then this one might be my favorite, affirmative disclosure in the absence of job postings. So none of the jurisdictions actually require you to externally post your job for the new hires. And so some employers said, well, if I don't have to post the job, then I don't have to comply with the job posting requirements and put the salary range in the postings. But Illinois and Maryland specifically say that if there is no public or internal posting for the position, the employer still must disclose the wage range to the applicants either before before a discussion of compensation or upon the applicant's request. So it's not so easy to just kind of get around the requirements by saying, hey, there's no requirement to post, I'm just not going to post the position. Another kind of key differentiation is whether or not you're permitted to use hyperlinks. So as you can see, all of these different jurisdictions have a lot of requirements. The job postings can get pretty big and detailed with all of this information that's required now. So some employers are asking, are we permitted to include this information in the posting, but use a hyperlink or a link to another site or another document that includes all of these details so that they're not in the postings themselves? And some states like Colorado and Illinois have said yes. Other states like Washington and New York have said yes, but, and they put a caveat on it. And California says you can't link the actual pay range or the pay scale has to be included in the posting. I'm going to skip over enforcement now. We're going to talk about it in a few minutes, but as you can see, there are a ton of nuances here. It's not easy to craft a nationwide approach that's fully compliant in all of the jurisdictions. So I just want to touch on the next slide. Just some things to think about if within your organization you are going to try to have more of a streamlined or nationwide approach. So the first thing to consider is, will you have different approaches for remote jobs versus jobs that are at a physical location, right? So jobs at a physical location are a little bit easier because you just include the range that's specific to that physical location. Remote jobs that can be performed anywhere, that gets a little bit more difficult because you have to be careful about those jurisdictions that we talked about that require site-specific or location-specific ranges. So that's the first thing you'll want to think about. The other thing to think about is your comfort level with being over-inclusive and potentially disclosing more than you're required to for some jurisdictions. So for example, some jurisdictions require the general description of additional benefits and other forms of compensation, and others don't. So are you as an organization okay with saying, let's just include a little bit more than we might be required to in some jurisdictions, just to be able to have a unified approach across the states? And then lastly, and this is probably one of the most important questions, is what's your priority here? Right? Is it simplifying the process and reducing the burden of analyzing each job posting and what needs to be included in it? Or is it ensuring strict compliance with all jurisdictions to avoid any kind of penalties or violations or even lawsuits? Or maybe it's a balance of both. So it's important as you're thinking through these to just say, you know, what is our thought as an organization as we proceed with coming up with a plan? And the other kind of important piece is to really stay on top of this, because a lot of the nuances that we discussed, they're not written in the bill or the law themselves. They come out later and they're clarified in rules or guidance or FAQs. So it's really important to stay up to date, have someone who's focused on this and constantly looking for updates. We have a whole team here that are constantly scouring all the different state and local jurisdiction websites to see if they've put out any new comments or FAQs, and some of them even initially put out the FAQs and then they update them regularly. So it's really important to stay up to date on these. On the next slide here, I'll just touch on enforcement and litigation trends. Very quickly, obviously, this is just a sampling. It's not all of the states that have these requirements. Most jurisdictions are really focusing on helping employers comply or get into compliance. So there's not an abundance of violations that have been issued at this point. I think the most interesting to me is Washington. They've only had a handful of fines issued by the Department of Labor and Industries, but there are hundreds of class actions that many of you all have probably heard about by now. These lawsuits are almost identical, and a lot of them are filed by a single law firm. There are some plaintiffs that are the same across each lawsuit, so it kind of gives the appearance of them just applying to companies' sites or postings that are not compliant, and it leaves people wondering whether they actually were interested in the job. So this is potentially a huge problem for Washington employers because if successful, each plaintiff can recover $5,000 each plus attorney's fees. So some of you have positions where you get tons of applicants. If you have 500 applicants, that's 2.5 million right there, easy, right away. So the question really has become, who's considered an applicant under these laws? Is it anyone who applies for a job, or is it a bona fide applicant who's actually qualified? And Washington Supreme Court is actually looking at that question right now, right? What must a plaintiff prove in order to be deemed an applicant under these laws? So depending on that outcome, the results could end up with significant liability for Washington employers. On the next slide here, I'll just touch on pay data reporting. If we go one more further. So right now there are currently 3 states that have pay data reporting requirements. I won't go into detail about, the basics of all of them. The California and Illinois have been on the books and you've been required to report for years now. So I assume we all either know the basics of what that's required there, or you potentially don't have enough employees in those jurisdictions, so you don't have to worry about it. But basically, California requires 2 different reports, the payroll report and the labor contractor report. Those reports this year are due on May 14th. And really the only new thing there is the option to include data on Middle Eastern or North African employees if you collect that data. Illinois, again, it's very similar to what it's been in prior years, but there are new data reporting requirements. So for those of you who filed or certified last in 2023, it's your time now in 2025 to recertify. And the new data requirements are to whether or not the position is subject to a collective bargaining agreement, whether the employee's hourly or salaried, and then the hourly rate for hourly employees. And Illinois is also giving the option to include MENA data as well. And then the last and the newest, the latest to join the party is Massachusetts, but they kind of only halfway joined the party because they don't actually require wage data to be submitted. So the law requires employers with 100 or more employees in Massachusetts to submit wage data reports, but they define those wage data reports as federal EEO-1 reports. And those federal EEO-1 reports currently don't include any pay data information. So while Massachusetts employers have to submit their EEO-1 reports and they're due February 1st each year, there's not actually pay data in them at this point. Massachusetts has said that it wrote the law to mirror what the EEOC does on the federal side. So if the EEOC ends up including pay data again at some point, then Massachusetts would require that too. But currently it's just your EEO-1 reports without the pay data. And with that, I will turn it over to Caitlin to touch on the global side.
Thanks, Christy. So we've talked about a little bit about what's happening in the U.S., particularly with respect to reporting. So now we'll turn to what's been happening outside of the U.S. So on the next slide, we'll first take a look at kind of global trends, what's happening. So on the slide, you'll see these are examples of where there are pay reporting obligations for employers. And as you can see, really a lot of those reporting obligations arise from European countries, but it is true that other regions are taking note as well. So as an example, last year, Brazil enacted a new reporting requirement, and there was a little bit of kind of change in how it ended up actually going into effect, but essentially where it landed was that the government prepared reports based on information that was submitted by an employer. An employer has to submit certain information through certain systems, and the government would then compile that information into a report. It was then up to the employer to post and disclose that report. So that's just one example of how there's reporting kind of changes outside of Europe, but it is true that the bulk is still within Europe. So on the next slide, we'll look at a few additional examples. So we've mentioned Brazil, but we have a few more that you can see here. For example, France has an obligation for organizations with 50 or more employees, and in that process, there is what are called indicators, and there's 4 or 5 depending on the size of the company. And it's basically based on an index that looks at things like wage gap, gap of individual salary increases, among other data points. And then that report has to be published by the employer. Similarly, in Germany, there are obligations that occur typically for most employers every 5 years or 3 years. And in that case, the report gets filed with the Federal Gazette. In Australia, employers with more than 100 employees have to report on specific data points, again, having to do with gender composition in the workforce, remuneration between men and women, various number of data points. And those reports are submitted to an agency called the Workplace Gender Equality Agency. And interestingly, last year, for the first time, that agency released company names along with the respective data on pay equality. So I think when we start thinking about this, we could go on forever about what the requirements are, but I think it's more helpful to think about what are the trends that we can draw from these examples. And what we're seeing is that in recent years, there's an increase in countries that are focusing on public or government disclosure requirements, whereas previously we had seen a lot of countries looking at internal analysis. So employers being required to do the analysis, but able to keep the outcome of that analysis internal, not having to publicly post it or not having to report it to a government agency. So we've been seeing a kind of a big shift there. And so that trend seems to be in favor of public disclosure. And to that point, we'll kind of shift into what are we seeing coming. And one of the big things that's on the horizon is the EU Pay Transparency Directive, which involves significant reporting obligations that are very much outward reporting obligations. So on the next slide, we'll hit on some of the basics. So what is the EU Pay Transparency Directive? You may have heard of it by now. The directive was issued, it's been issued for over a year now. And I think what's important to remember is that the directive itself does not impose the laws on employers. What the directive does is it says to EU member countries, EU country, you have to transpose a law that at a minimum takes this directive framework and implements a law in your country. And so the directive requires that local laws are transposed by June 7th, 2026. So this June coming up, it'll be about 1 year until the laws have to be transposed. And so where are we on transposition? Well, there's not been any sort of fulsome transposition by any EU country. Sweden, Poland, and Ireland have issued various forms of drafts, but nothing's been enacted or imposed so far. Sweden's draft, for example, follows largely what is in the directive, but there's also additional points that are in it. Sweden has existing pay transparency and pay reporting laws. And so there are aspects of the existing law that are also captured. And so I think that's a watch out area as we watch this space, bearing in mind that the directive is a framework, but countries as they impose or transpose the laws can include other requirements, or they can lower headcount thresholds, for instance. And so it's an area that we're watching closely to follow. In Belgium, there is a region that kind of transposed through a legislative means a law that essentially follows the directive, but it is applicable really only to government institutions in their hiring. And so it's expected that Belgium, as kind of the broader country, will come down with their laws. There are other countries, including Spain, Germany, and the Netherlands, that also have draft legislation in progress, but there's not been any sort of large spread release of those drafts. So what will these new laws require of employers? On the next slide, we can talk a little bit about some of the highlights. One of the highlights is that there's going to be a significant focus, I would say, on job applicants and their access to pay information. So job candidates will be entitled to seek pay information from their potential employers. It'll be related to initial salary or range, any collective agreements applied by the employer, and it's intended that the information is presented in a way to facilitate pay negotiations. It's not clear whether it will have to specifically be in the job posting before an interview, but the information will be readily available. There's also going to be a big ability for workers to obtain information. So workers will have a right to have information about their own pay and pay of employees in similar categories of work, or same categories of work. And so there's also a right for workers' representatives, your works councils or other representatives, to be able to get that information for employees. And so the trend, as we've kind of noted, is very much transparency. There's not going to be really an ability for an employer to kind of hide behind their ranges or not disclose this information, because both employers and workers' representatives are going to have a right to it. So on the next slide, we'll talk a little bit about pay reporting obligations. And this has been a big one that a lot of employers have started to focus on. And on the slide, we talk about the various data categories that employers will need to report on under the directive. And when we look at this, we think, how does a company even start to think about this? And when we look at the directive, there's some guidance on how to start to address it. And essentially, the analysis looks at pay structure, and it defines work of equal value as being based on non-discriminatory, objective, and gender-neutral criteria, which includes skills, effort, responsibility, and working conditions. So this is really kind of important to bear in mind when companies are considering how to group employees and how to categorize employees. That's particularly true if there's not an existing job architecture within the company. And I think it's important also to bear in mind that the analysis is not just going to be based on base salary, but is also based on what the directive refers to as complementary or variable pay components. And so these are things like bonuses, allowance, variable pay. It can be looking at benefits as well. And so there's a lot of categories, occupational pensions, for instance, also included. And so bearing this in mind as well when collecting the data to do the analysis, really paying attention to what has to be included and what can we use to explain any sort of differences. What's also important is, back on that transparency trend, the accuracy of the information then gets confirmed by employers' management. There's consultation with workers' representatives, and those workers' representatives have access to the methodologies that employers are using to actually do the analysis. So, I think what we can glean from all of this is that there's not only kind of an obligation to report, but there is also an obligation to share how did we get to our outcome. And what's really critical for employers, as we'll talk about on the next slide, is kind of the risk of having a joint pay assessment. So if we go to the next slide, we can see that if there's certain criteria that's met, a joint pay assessment will be required. And what is a joint pay assessment? Well, essentially, it's an employer having to really work with and in conjunction with the workers' representatives, again, your works councils, your unions, your other employee reps, to go through a process to really assess why is there more than a 5% gap. And the joint pay assessment includes a number of kind of obligations and factors that have to be looked at. A few examples are that it includes an analysis on pay levels. It looks for the reasons for the differences in those pay levels. And then there's also an obligation to, in this joint assessment, to look at measures to address the differences in pay if they're not justified on the basis of objective gender neutral criteria. The joint assessment can also include an evaluation of the effectiveness of measures from previous joint assessments. And so we start thinking about the potential risks that an employer may face if they have to go to a joint pay assessment. And we start thinking about what can we do now? So on the next slide, we talk a little bit about what can employers be doing, bearing in mind that the directive does still need to be transposed into law in the various countries. But the directive gives us the framework. We know that it is at a minimum what we're going to have to deal with. And so there's a few things that employers can do now to start preparing and getting themselves in a better position so that when the reporting cycles start in 2027, there's a less likelihood of having to go to that joint assessment stage. Those things include, for instance, checking your head counts and your entities, remembering that under the directive, it's not just looking at a certain country, but looking at if you have multiple entities within that country. It does look at head count on an entity level. So, it's also ensuring that you're assessing any sort of impact that it may have. So when you look at where's your footprint, remember that the reporting is being phased in by headcount, starting with the biggest locations first with 250. That's the first obligation in 2027. And so figuring out what are our priority countries, where do we really need to focus our initial energy, where we can kind of go through the process, learn, and then implement for countries that have lesser headcounts. Again, remembering that the headcounts under the directive could potentially be lower when we look at how the laws ultimately get transposed. What we think is a smart thing to do now is running pay assessments in 2025 and doing remediation work where possible. When we look at the timing, the first reports are due in 2027, which means that it's 2026 data that's going to be used for those reports. And so in 2025, there's time to really take a look at how are employees categorized, what are we pulling in terms of data, how do we look at that, potentially running assessments now, and if it's feasible, doing the work now. It may not always be feasible, but at least starting to think about what can we do to get ready for when these reporting requirements go into place. And on the next slide, we'll just talk a little bit more broadly about achieving global compliance. So we've talked a lot about the Pay Transparency Directive, preparing for that, but remembering that there are current obligations as well. And so kind of going back to that piece about ensuring compliance now, which is looking at internal headcount tracking and comparing that to jurisdictions that have obligations that already exist. Of course, we need to prepare for the upcoming obligations, but the obligations are here now too. And so I think what it really comes down to is understanding the obligations, identifying where the company has obligations, and ensuring that those obligations are met. And how do you do that? It's understanding what to track and report, the timing, because of course it's country by country. The timing is not uniform. So keeping track of where there are obligations, what does the timing look like, and then understanding, okay, we have obligations, but what exactly do we have to do? Do we have to just do something internally and post it to our employees? Do we have to submit with the government? And so understanding what really is required of the company, and ensuring that that's being carried out. And of course, if there are any sort of employee representative consultation obligations, ensuring that not only are they being met, but planning as well, planning for any sort of consultation, the time that may take, and planning for any sort of documentation or reports that need to be prepared in advance of filing deadlines. And so knowledge is power with these obligations. Understanding where you have the obligations and how to tackle them can be really critical and ends up being quite key in terms of ensuring compliance around the globe. So with that, I will turn it back to Annette to discuss equal pay in the US.
Thank you so much. And so if we go to the next slide, I mean, one of the important things to level set and start off with, right, is that U.S. federal law has not changed. We've got the the Equal Pay Act. We have Title VII. Both of those laws address compensation in the workplace. But in the US, we are dealing with several executive orders, and so we're getting a lot of questions about them. In particular, Executive Order 14173, that I'm sure many of you are already familiar with, talks about ending illegal discrimination and restoring merit-based opportunity. And as a result of that, as well as administrative actions that we're seeing from various agencies on diversity, equity, and inclusion programs, I'm getting a lot of questions, and many of us are, can I still conduct a pay review? Should I conduct a pay review? And if so, are there changes I should consider? And from our perspective, the answer to all three of those questions is yes. You should continue to engage in a pay review if you've done that in the past for a variety of reasons. And on the next slide, you'll see that, certainly equal pay, in light of everything that Caitlin and Christy have already shared, equal pay issues are still critically important, right? And part of a tool that employers have at their arsenal is to conduct an equal pay review to make sure that you don't have potential discrimination that's happening within your organization. And pay is very unique. It changes quickly as the market changes, as you get new workforces and workforces leave, and you have different approaches in terms of the work that you're doing. It is a rapidly changing cycle that occurs with regard to compensation, and doing an analysis helps you understand where you might have pitfalls or challenges. The EEOC, their recent guidance that just came out last week on the executive order and some of the employer diversity inclusion practices, specifically identified compensation as a prohibition against ensuring that there is no disparate treatment, right, or unlawful employment practices with regard to compensation. So that remains viable. And even Robbie Starbuck, who has been very, very active on social media with regard to employer diversity, equity, and inclusion practices, has also come out very specifically on pay equality and ensuring that there is equality in the workplace with regard to pay. So on the next slide, so I think the answer is can I, should I? From our perspective remains yes, you should continue to evaluate. The question is how then, right? What should we be doing? How should we be thinking about these issues? I can tell you that at Seyfarth, we've spent a lot of time thinking about, re-examining our approaches and how we analyze certain, our models and how we might build them. And we have the benefit of having in-house labor economists that we partner with to develop the statistical analysis, but we're also reaching out to external labor economist partners or other statisticians that end up providing expert testimony in litigation to sort of think through or reimagine how we analyze pay or how we think about pay when you're talking typically about thousands and thousands of pay decisions that have happened and what's the best approach. So we certainly recommend that you think about reassessing, reevaluating your analysis methodology. How should it be established? Who are the relevant comparator groups, right? So when you look at some of the guidance that is coming out from the diversity, equity, inclusion perspective, right, you cannot or should not be thinking about groups or focusing on certain groups without looking at all groups, right? So when you're evaluating or conducting an equal pay study, it really is important to think about all the groups and how you do the comparison. So one of the big questions we've been batting around and talking about is whether, what's the right group to compare, especially when it comes to race, for example. In the past, many employers would analyze the pay of a particular race group, for example, against white. Is that still the appropriate analysis that we should be taking? Are there changes that we should be making? I think we're, thinking about conducting what we're referring to as a favored group analysis, but how, and favored group literally means, which is the group that has the highest pay and you let the data lead you to where that is. But how you engage in that particular review is quite nuanced. And that's the piece that, you know, we spend a lot of time talking about internally and continue to do so. So those are the kinds of issues that you should be talking about with your legal counsel, as well as any labor economists, statisticians that you have working on the analytical approaches. And it really is helpful when you have flexibility in how you can set up the modeling to make sure that you are addressing multiple issues and you're taking a closer look at the impact. You know, there's different ways of looking at a favored group. Are you looking at average pay? Are you looking at a median pay analysis to kind of identify the highest group? Or are you looking at pay differences using some of the control factors that you build into your regression model? So all of those could come to bear to really think about what works best for your organization in terms of setting up the model. And then when you do have areas that pop as potentially needing further review, how are you going to prioritize or investigate? Given that we understand there's limited time and resources and oftentimes budget, so how do you attack it in a individualized way based on a potentially company-wide analysis? So there are strategic considerations. Some companies have done kind of every other year look at different groups. They're looking at groups throughout, but they'll take one group and break it apart and look at it perhaps every other year. There's other strategies for thinking about it, but those are the kinds of issues you should be talking about. When you review your outliers, how are you going to conduct your review? I happen to think that the individualized review is arguably one of the most important parts of the entire analysis that you do, because it gives you insight into the why behind identified pay differences. So certainly we could make adjustments to compensation, but really what is so critical and so important behind doing an equal pay analysis is to understand the why. What is causing the differences? Do you have geographical differences that are legitimate in your processes that you aren't adequately assigning in your compensation system? I mean, we hear that all the time. Employers will say we don't pay different across geographies, but when you run the analysis and you get that feedback as to why an individual is paid less or more than their peers, we often get that as feedback. Well, then that becomes an important informational tool to say, well, should you be controlling for it? Should you be building a geographic structure or tiers in your structure? Or it could be not so much the geography, but the type of business that that particular individual is in. We have some employers that have different brands within their organization. Some brands or some products are higher, higher revenue generating work streams. And so is there a way to build that into your compensation structure and then test that when you run your analytics? So certainly getting that more detailed insight is critically important. And then how you remediate is also important, especially in light of the executive order changes. Looking at all groups, equal pay applies to all workers, regardless of race or gender, and it's important to make sure that when you're running your analytics, you're keeping those principles in mind. Certainly establishing your attorney-client privilege is key, as we'll talk about in the next slide when we talk about equal pay considerations. And these are very sensitive areas to really think about, to go back and forth about, to understand why you have differences in compensation. Sometimes it is appropriate to make remediation adjustments, and sometimes it's not. You have the underlying reasons that support the pay differentials, but understanding that and being able to run those analytics and have those meaningful discussions under privilege is key for purposes of assessing the relative legal risk that you have. So on the next slide, another area that we're talking a lot about with employers is the communication strategy. There are questions that are saying, hey, should we start, continue, revise, or end these communications, whether it's internal or external, formal or informal, about our equal pay study? How should we be thinking about that? And here I will add again attorney-client privilege issues. When you get our litigation materials, you will see that we have a section on attorney-client privilege. And there's at least one case that just came up this past year that, you know, in addition to a few other things that they were looking at, the court relied on the fact that the company posted what their pay gap was. And so they viewed it as, while, you know, the initial work was undertaken under privilege, they eventually had a couple of iterations of it. And because they posted the information, the court held that even if the attorney-client privilege was maintained, that the posting of the information would be considered a waiver. Now, I'm not saying that every court would take that position, and I'm also, you know, the specific facts are important, but that is a consideration that you should be evaluating. The terminology is also important, probably here more important than it had been in the past. Are you using terms like pay equity? The term equity has recently come under attack in terms of what that actually means. Certainly we tend to focus on equal pay, but other employers are also thinking about pay fairness, pay parity. What do those terms actually mean? So if you are using a term like pay equity, what does it mean for your organization, and how would you define it? And if you choose to disclose a pay gap, how might you communicate that pay gap on a go-forward basis? So we've often seen, for example, a minority gap in particular disclosed as, you know, African Americans earn, you know, X percentage, or, you know, X percentage related to white employees. Is that the proper way of describing it? Are there other ways to consider? Should you just simply, if you're looking at a pay gap disclosure and you want to continue to do that, would you be willing to open it up and just list all of them? All of those considerations should be part of employers and their pay analysis and what they're doing now. There's pros and cons on all sides of it, but that's where your legal counsel is going to be critically important as you consider the go-forward approach. So I'm going to quickly move to best practices and takeaways as we go through the next section of the slides. And certainly, you know, best practices remain. Go ahead to the next slide. You'll see that, you know, it is so critically important to have a comprehensive structure and philosophy. And we understand that some employers, you know, and this is difficult. This is hard work, really putting all of your jobs in some sort of compensation structure. But that will help you in the long term really think about each job, the value that you place on each job within your organization, how you value experience within your organization, or how you value performance within your organization. It will help you in the pay transparency information that Christy and Caitlin shared, right, in terms of the ranges. It would help you see if you have people above or below the range and how they got there, why they got there, and are there changes that need to happen. Sometimes we see people at the very, very top, and really when we question that and say, hey, what's going on? They're standing out as an outlier, and we could also see that they're at the top of the range. It turns out that maybe they're doing work that's much higher level. Well, if that's the case, should that individual really have a promotion in place? So those are considerations that having a comprehensive compensation structure and philosophy will help you with. And you want to have an effective job structure that clearly defines the work that is being performed. In the 50-state survey, you will see that many employers, many states are moving away from, you know, equal pay for equal work. Many of them are saying it's equal pay for comparable work or substantially similar work. Well, how do you define that if you don't have a very good structure with regard to your jobs themselves? Thinking about how the company sets salary at various stages is important. What your starting pay philosophy is critically important for purposes of the pay transparency requirements. Thinking about promotional increases and how you're going to set them. And we see, you know, sometimes we see caps in them. And if that is driving pay differences, you'll want to rethink that. And that's the why, right, that you might identify in your pay study when you really look at the outliers and take a closer look. Departmental transfers sometimes can be the result, or be causing some pay differences because one department might, generally speaking, pay more or less than another department, and when folks transfer and move, sometimes they carry the old compensation because of that historical information. And that certainly is a factor other than race or gender that might be driving the differences. But having an understanding of how you document that, how you maintain that, in case there's ever a question, is beneficial. On the next slide, I won't spend a lot of time talking about the pay studies because, you know, we've talked about that a little bit, but it does help, right, to test your job architecture. It helps to test your compensation strategy. If you say you pay for performance, does your compensation analysis reflect that? And if it doesn't, you know, do you have issues that you need to address? And certainly it helps you to reassess any practices that might lead to an unexplained pay difference. Of course, making adjustments to individual pay is important, but that higher level thinking about the drivers and how you might address those is really part of the long-term strategy that you should be thinking about. I think it's also important to have other types of reviews, other ways to analyze your compensation. So looking at things like the compa ratio, where is an individual's pay relative to the pay range that you have set up is important. Assessing, you know, the pay of the of peers in the group at the time of hire, at the time of promotion, so that you can see, okay, I'm bringing someone into this job, or I'm bringing this person into a particular role when they're getting promoted. How does that impact the overall group is also really important, as well as at the time of merit increase. If there's any way to do a pay review annually and then also sort of check what the merit increases will do, that is actually ideal and oftentimes can be done in a very quick turnaround window to kind of double check those merit increases aren't creating pay inequities. You want to make sure that you have a process for addressing and correcting compression issues. We often find that that is a driver of pay differences that we see. And then, you know, the issue that I often see is that, you know, we talk a lot about a pay gap, but there's often really more of a data gap. And you know, we talk about this internally quite a bit, as well as with our clients. You know, one of the factors that I always see is often missing is the relevant prior experience that a particular employee brings when they get hired. And starting pay is one of the most critical decisions to that employee's compensation journey, right? And so making sure you track that, and like I said, most employers don't. You make a decision, and there's lots of discussion at that early stage, but 3 years down the road, 5 years down the road, you don't remember why you set the pay higher or lower than others. And it's not just a quantitative prior experience, right? How many years they are in the industry or in the market, but it's also the quality of experience. You know, what were they doing in their former roles? How comparable is it to what they're doing with your organization? So all that information is critically important. And on the next slide, we'll talk about the pay transparency practices, right? So you want to make sure that you are partnering with your key stakeholders on your compensation strategy. I saw a question, Christy talked a lot about the you know, kind of the national, like trying to come up with a national approach versus a state-by-state approach. And I saw a question come up in the chat to say, you know, what is there a way to identify sort of the strictest state? And it's very difficult. I mean, off the top of my head, I would say that Colorado is viewed to be as one of the more challenging, along with Washington, but you have other nuances in other states that make the wholesale, you know, which one is the most challenging, and then sort of complying with that one because it'll sweep everybody else in. If you have a remote high remote workforce as compared to others, it's going to raise some challenges and nuances in trying to get to each piece. On the next slide, you'll see, you know, you really have to have a strategy for addressing questions from employees that are in jurisdictions that do not have pay transparency requirements. So you might see, they might see that you posted the pay range in a different jurisdiction, but they don't have a requirement. They might ask questions because it's their same job. And same with current employees. As you're sharing information with applicants, your current employees often have questions about, wait a minute, that's the pay range that you're posting? what about my specific range? So developing talking points and FAQs for leaders and employees, I think, is also very important. And on the next slide, you will see that we really encourage you to have very robust contemporaneous documentation. That is very important for if you do get tagged in litigation. You want to have consistency. If you say in your compensation structure that performance matters or that it doesn't matter to where someone's at, that information will be a part of any litigation that comes up. Very quickly, I will remind you of our thought leadership pieces that will be forthcoming, and then let me read off this CLE process. Let's land on that last page. If you will scan the QR code that's up, it's also in your email that you received. The code is SS3803. That's Seyfarth Shaw, so SS3803. One more time, SS3803. We thank you so much for joining us for this session. We hope that you found it useful, and please reach out if you have questions.